certainly delighted to be back.
Okay, I'm going to start with just a quick correction that Mr. Austin asked me to make from the last panel. He had referred to a gentleman named Steve Taylor, but his name is Stephen Parker. So just that correction from the previous panel. Okay, with that, I'd like to introduce our second panel of the morning, focusing on voting rights. This panel will address current voting rights challenges and strategies for reform, whether through litigation, legislation, or mobilization. The panel moderator is Steve Mulroy, who's a professor of law at the University of Memphis Cecil C. Humphrey School of Law. Professor Mulroy teaches in the areas of constitutional law, criminal procedure, and civil rights, and is a former civil rights lawyer for the United States Justice Department and former prosecutor. As a law professor, Professor Mulroy has participated in the litigation of a dozen cutting-edge cases in areas which inform his scholarship. He also served as an elected Shelby County Commissioner from 2006 through 2014. I'll also like to introduce our panelists, at least briefly. Mr. Debo Adegbile, a partner at Wilmer, Cutler, Pickering, Hale, and Dorr in Washington, D.C. Next to him, Ms. Sherrilyn Ifill, President and Director-Counsel of the NAACP Legal Defense and Education Fund. Then Professor Mulroy, and to his left, Pamala Karlan, the Kenneth and Harle Montgomery Professor of Public Interest at Stanford Law School, and at the far end, Rick Hasen, the Chancellor's Professor of Law and Political Science at the University of California, Irvine School of Law. So I'll turn it over to Professor Mulroy to moderate our panel.
Thank you, Dean Letsu. And good morning to all of you. Good morning. Glad that you're here. Thank you very much for coming, and I want to thank our panel as well for coming from different parts of the country to participate with us today. I'm going to briefly introduce each of our panelists, give a little bit more detail, and then I'd like to foster a discussion among the panelists, and I'll get to that in a moment. On my far right, as Dean Letsu already mentioned, is Debo Adegbile. He is a partner at the law firm of Wilmer Hale in D.C. He is actually currently serving as a commissioner on the U.S. Commission on Civil Rights, having been appointed to that position by President Obama. At the law firm, he co-heads the law firm's anti-discrimination law practice. He also, in the past, had served as an acting president of the NAACP Legal Defense and Education Fund, had testified on a number of occasions before Congress on voting rights issues, and also litigated two important Supreme Court cases having to do with the Voting Rights Act, Namudno v. Holder and Shelby County v. Holder. So we're very glad to have him here. Next to Debo is Sherrilyn Ifill, who is currently serving as the president and director-counsel of that same NAACP Legal Defense and Education Fund, where she had spent a number of years litigating a number of different voting rights cases. When I was at the voting rights section of the Department of Justice, we often worked with the NAACP LDF. They're one of the preeminent organizations in this area. She's a critically acclaimed author, and her book, On the Courthouse Lawn, Confronting the Legacy of Lynching on the 21st Century, reflects her lifelong engagement in an analysis of issues in American public life. To my immediate left is Pam Karlan, who is the Kenneth and Harle Montgomery Professor of Public Interest Law at Stanford Law School and the co-director of that law school's Supreme Court Litigation Clinic. She has also, in the past, served at the NAACP LDF. She clerked for Supreme Court Justice Harry Blackmun. And she also served at one point as the Deputy Assistant Attorney General of the Civil Rights Division of the U.S. Department of Justice. Finally, on my far left, we have Rick Hasen, who is the professor, who is the Chancellor's Professor of Law and of Political Science at the University of California, Irvine School of Law. Professor Hasen is a recognized national expert in election law and campaign finance law, co-authored a leading casebook in that area, and currently manages the influential and indispensable election law blog and election law listserv. And he was also elected to the American Law Institute in 2009. So thank you all very much for being here today. What I wanted to mention before is I'd like to simply facilitate a discussion among all of you. I'm going to ask some questions that I'm going to throw out to any panelist who wants to answer. You're not required to answer. You can answer more than once. And if you have questions or comments among each other, I encourage you to discuss it among yourselves. I'm just here to facilitate. So with that, let me begin with this question. Not all of you are professors, but a lot of you are, and all of you are familiar with the concepts of grading. If you were to grade the progress that we've made since Dr. King's time in the area of voting rights, what grade would you give? In your opinion, where have we succeeded? Where have we failed? And to the extent that Dr. King's vision has only partially been achieved, why do you think that's the case? Anybody wants to start?
Okay. Well, what you left out of my bio is that I was a professor for 20 years at the University of Maryland Law School. So I'm quite familiar with grading, but the truth is I always preferred comments to grading, so I'm not going to issue a letter grade. But I will respond to the spirit of the question, what has been successful and what has not been successful. I think there's no question that the movement to ensure that African Americans have the ability to participate in the political process in this country, particularly in the South, has been one of the areas of tremendous progress in this country. The 1965 Civil Rights, Voting Rights Act is often referred to as the crown jewel of civil rights legislation, and understandably so. Now, without question, those jewels shone more brightly prior to the Supreme Court's decision in the Shelby County case, when we still had Section 5 of the Voting Rights Act, which required a number of jurisdictions with a history of discrimination in voting to submit any voting changes they wanted to make for preclearance to a federal authority. This was extraordinary because this was the one civil rights statute that allowed us to cut off discrimination at the pass before it happened. And it was remarkably effective. Now, I'm not one of the people who thinks that the preclearance years were Shangri-La, because like a number of the people on this panel, I litigated voting rights cases with the preclearance provision, and we never lacked for work. So we know that Section 5 did not produce Brigadoon, but it did allow us to proactively engage issues of voting discrimination. If you look alone at the tremendous change in the registration of African Americans in the South, particularly immediately following the Voting Rights Act, it was almost extraordinary. Counties like Dallas County, Alabama, where African Americans constituted 51% of the population, only 1% of African Americans were registered to vote prior to the Voting Rights Act. And so this was an extraordinary a piece of progress. I think it's also true that there's been tremendous progress in electing African Americans to political offices around the country at the local level in many jurisdictions, some at the state level in some states, and certainly even the President of the United States. And I certainly think the election of the President of the United States, and by that I refer to Barack Obama, would not have been possible without the passage of the Voting Rights Act. And the passage of the Voting Rights Act came as a result of tremendous activism, tremendous courage by people like John Lewis and others who marched across the Edmund Pettus Bridge, and who insisted on the importance of this Voting Rights Act. But that being said, I do want to make sure that we are clear about Dr. King's ambitions and what he thought voting rights meant and would do, and what he and many others in that movement thought voting rights would do. The point of African Americans participating fully in the political process was not just symbolic. Yes, it is true. It is the ultimate reflection of full citizenship in this country, the ability to cast a ballot, to participate equally in the political process, and so it was critical for that reason. But it was also expected to allow African Americans to have a role and to take the power to change the material condition of our lives. That was the whole point of participation in the political process. And in that realm, I would say it's a little bit less successful. And, you know, if you look back to Dr. King's, one of his most famous speeches, Give Us the Ballot, which a speech he gave in May 1957 at the Lincoln Memorial, and the speech was really designed to address the failure to implement Brown versus Board of Education. But in that speech, he goes through saying, give us the ballot, give us the ballot, give us the ballot. And he says, give us the ballot, and we will, you know, elect representatives who can be transformative. He says, give us the ballot, and we'll elect judges in the South, referring to the previous panel, who will do justice and have mercy. And we'll elect people to the governor's seat, who will have a touch of the divine. I mean, he had this kind of elevated sense of what this could mean transformationally. And that aspect, I think, is the part that is still unfulfilled. And I'm sure in this panel we'll talk more about the ways in which it's been unfulfilled, but I think that's the piece that we're sitting with. And I think there are lots of reasons why it's unfulfilled. It's one of the reasons why this panel, although it comes second in the day, in many ways touches on all the other panels throughout this two-day symposium, because voting rights is connected to education and connected to criminal justice and connected to education and all the other issues that we're talking about over the next 2 days, is this sense of how do you unleash transformative political power for marginalized groups. King certainly thought that that potential was there, but I think he also recognized the scale of the challenge, and we haven't fully scaled that wall yet.
Can I just jump in and say here, you know, Sherrilyn is 100% right that the Voting Rights Act of 1965 is the crown jewel of civil rights laws, and it's the centerpiece of what came to be known as the Second Reconstruction. One of the things it's worth remembering is there was a first Reconstruction, and that first Reconstruction failed. And so if we were using a figure, I'll just use one figure, which is 80%, which is during Reconstruction, 80% of black men voted in the United States. And then that number went down below 1% by 1900. So it's important to recognize that Reconstruction is an ongoing process, and the first Reconstruction failed in part because of the disenfranchisement of African Americans in the South. And that's one of the reasons the Second Reconstruction was necessary. The second thing that Sherrilyn pointed to that I want to highlight, Dr. King's Give Us the Ballot speech is a wonderful example of this, is the idea that voting is really about three very separate things. The first is that symbol of full citizenship. The right to participate, the right to cast a ballot and have it counted. And when Sherrilyn and I were doing voting rights cases full time, everybody assumed we had solved that first generation problem, and we were on to what came to be known as the second generation problem, which was voting's not just about the symbol of your ability to cast a ballot and have it counted, it's also about who wins and loses elections. And so we spent a huge amount of time on redistricting cases and judicial election cases to set up systems where African Americans and Latinos could elect the candidates of their choice to these offices. And we thought we had that kind of on the run. And so we were starting to think about that third generation of cases, the cases about governance and about making changes in legislatures. And that was what Dr. King's Give Us the Ballot speech was really about, was you give us the ballot and we go straight to the third generation of cases. And so he said, you know, we'll be able to get rid of things like stagnant and hypocritical federal Congress. Sound familiar? And then he talked about the blatant hypocrisy of right-wing reactionary Northerners. Sound familiar? And finally, he talked about how giving the vote to everyone would get rid of the high blood pressure of words and the anemia of deeds, dealing with the issues of critical importance to people of color in this country. And we haven't gotten to that third generation yet. Indeed, what we're now seeing is we're back litigating the first generation again. So the very issue that was at issue in 1965, which was the ability of people to register to vote, to cast a ballot, and to have that ballot counted, is back on the front lines again. And that's absolutely critical for people to remember, that we can't really talk effectively about the third generation of problems until we solve that first generation problem so that everybody can vote.
Sure. Rick?
First, let me say it's an honor to be here, and I don't feel like I'm worthy of being on this panel, but I'm very, very happy to be included. First, I'll give a grade, since you're always supposed to answer the judge's question.
Thank you.
I'll say gentleman's C, you know, a C to be nice, because I do think that, especially if we're averaging it over time, I think the Voting Rights Act, when it was passed, that was a tremendous progress, but over time, we've lost a lot of the promise of where it was going. And if you read Dr. King on what his vision was of what the vote was going to lead to, he talked about coalition politics between African Americans and other Americans, and he talked about how that was going to better the lives of everyone. He talked about the Medicare, education, social justice, criminal justice, all of these things were going to be improved. And so if we think about why that didn't happen, going to the last part of your question, Steve, I think there are three main reasons why Dr. King's vision has only been partially fulfilled. The formal right to vote, of course, is there, but where is the material change in the position of African Americans and others in the country who were put at a disadvantage before the right was there? And the first thing I'd say is that parties have long been able to harness private racism towards political ends. First, it was the Democratic Party with the all-white primary, and that took Supreme Court action to get rid of. Today, it's the Republican Party trying to turn at least in the South, trying to turn the Democratic Party into the Black Party and to send a symbol that if you're a white voter and you're looking for the place to go as your party, you should not go to the Democratic Party. And so there's been this kind of message that's being sent as to what it means to be a Democrat or Republican that has racialized the politics in our country. The second thing is, and Pam alluded to this, is the failure of the Supreme Court to read the Voting Rights Act with the spirit of what it was meant to do in mind. And so the litigation attempts, which some on the panel were involved in, to try to get the Voting Rights Act applied to areas of governance, to apply to how legislatures do their job, has failed. And the Supreme Court has consistently rejected broad readings of the Voting Rights Act, going so far as in the Shelby County case to strike down a key part of that provision, and is now poised to make Section 2 of the Voting Rights Act, which is the main tool that's left of the Voting Rights Act, a much less effective tool than it has been in the past. And the third area, and we may get into this, is, and this is partly the Supreme Court's failure, is the role of felon disenfranchisement, which in terms of the numbers of African American voters is just staggering and was not the case at the time that Dr. King was speaking about voting rights. But if you just take into account the numbers of African Americans and others who have been disenfranchised because of felony convictions and the Supreme Court's failure to allow constitutional litigation to try to challenge that, I think that's a big part of the picture for why the voting rights vision of Dr. King has not been fulfilled.
Debo, did you want to comment on that?
Sure.
question?
So I will, as the only non-professor on the panel, brazenly ignore the request to assign a grade.
I'm used to it.
But I will pick up on some of the comments that my other panelists put on the table. I think that as we reflect on the years in voting since the passage of Dr. King and his great example and the movement that led to the Voting Rights Act, we have to think about a couple of things, and some of them have been put on the table. In particular, I like to think about how it is that we understand what progress means in the context of civil rights and what it doesn't mean. And that's an important theme that has run through the reauthorizations of some of the core provisions of the Voting Rights Act. How do you measure progress? When is enough enough? And do you dishonor progress by acknowledging that the aspiration is to do more and to push beyond what the current situation is? I think there's a little bit of a tendency to want to declare victory with respect to certain civil rights issues, and to come to understand or to treat the goal as if we're trying to move from a state of total privation and discrimination and racial caste to something that is ameliorative but not full participation and citizenship, and to settle in that space. And the aspiration of the Constitution, I think, of many Americans is to keep doing more, to perfect the Union. And the Voting Rights Act had that ambition. It was there to continue to push forward and not to use our progress to date as a limitation on what we can achieve tomorrow. And if you think about that mindset, that tension between wanting to declare victory and the ambition and aspiration to do more, that is essentially the debate that Congress had every time the Voting Rights Act provisions came up for renewal. They would measure office holding, voter registration, the amount of cases that were decided. Were some parts of the country worse than others? And there was this intense battle fighting about whether or not delineating all of the continuing problems was somehow dishonoring the passage of time and the progress. And I think that we are smart enough to hold both concepts in our mind simultaneously, that you can acknowledge and embrace progress. After all, that was the objective. It was Dr. King's objective. It's the objective of every civil rights law. But you can also own and wrap your mind around the fact that racial discrimination in our country has tended to be more persistent and to insinuate itself into more areas of the country, and in some cases to metastasize in ways that we didn't expect. And in the face of that reality, I think the need to do more is important, and that was what was coming to a head in the Shelby County case. A need, and that was the case that struck down core provisions of the Voting Rights Act. And it was the court's hunger and thirst to declare that we were in a different place, in a different era, and we had closed the book on those old days. And what have we seen in the wake of the Shelby County case? What we have seen is that we were treating symptoms and we were treating some of the causes, but we certainly had not stemmed the disease. And it has metastasized, and so we see lots of the voting measures and tactics that had been used in certain places jumping to other places. And so Justice Souter once called it pouring old poison into new bottles. And I think that's part of the challenge in the voting rights context today.
Well, thank you. And I just want to follow up on a couple of comments that have been made just for clarification purposes to make sure the audience is with us. So I believe it's already been made clear, but the Shelby County v. Holder case that you referred to, Debo, is the one where the Supreme Court effectively ended the preclearance provisions of the Voting Rights Act. So you no longer had to get preclearance of voting changes in advance to make sure they weren't discriminatory. Is that correct?
Yeah, and it had applied to some parts of the country that had the biggest demonstrated histories of discrimination in voting. And so some parts of the country had to essentially have new voting measures pre-approved before they could take effect, on the theory that the pattern of discrimination had been so consistent that it was putting a burden on voters, and they were having to try and dislodge discriminatory practices one by one, and it takes a lot of time. And so it shifted the burden of time and inertia, as the court said, from the people that were having the discrimination perpetrated on them to the would-be discriminators, and made them come forward and show that the new measure was not discriminatory. And that was the very important piece to which Sherrilyn and I have referred that the Supreme Court took away.
Right. Thank you.
And then, because it's actually worth spending a minute on the Shelby case, because I think it actually illuminates a lot of what's been discussed, and Debo has described it perfectly, and since he argued the case, he knows that this is in fact true.
For this audience.
In many ways, the Shelby case and the Supreme Court's treatment of the Shelby case reflects what I think Pam was referring to earlier, which is a kind of proclivity to regard the issue of confronting racism in public life in this country as a finite issue that has to be dealt with at particular moments, and that you tolerate the fact that you have to deal with it, but then it's going to be over. And then we're going to go back to, I don't know what we'd be going back to since it's always been with us, but nevertheless, there is a sense that there's a kind of temporary measure. And I think that pervades almost all of the kind of civil rights jurisprudence that I think has been so reactionary certainly in the last 20 years of the Supreme Court. And I think Dr. King recognized this. I mean, he talked about the fact that the success that had been achieved after the Voting Rights Act of 1965, he described it as, so we had the Civil Rights Act of 1964, we had the Voting Rights Act of 1965, and we didn't have the Fair Housing Act passed, frankly, in shame until a week after Dr. King's assassination. And what he said with the two major civil rights statutes that had been passed was that we had just achieved a measure of decency, right? A requirement that African Americans be treated decently in our society. And he said very explicitly that the next stage was going to be so much harder. He said that the decency piece didn't cost anything. He said it didn't really cost any money to ensure that African Americans were registered to vote and could participate in the political process. What would begin to cost money were the measures around housing and inequality and poverty and so forth. So when you look back at the civil rights movement, it seems like such a, was such a harrowing period. But he recognized that in many ways that was going to be the easy part. That convincing people that this was a much more long-term and in fact permanent struggle was going to be the difficulty. And so what you saw from the Supreme Court in the Shelby decision and what you heard from Justice Scalia, who in the oral argument described the Voting Rights Act as a racial entitlement. Now, Debo was standing in the well of the court maintaining his composure. You know, I was sitting with our clients, our Shelby County clients, and I could feel the indrawn gasp. Right? We had of course instructed them that, you know, we need to be quiet during this hearing. We can't respond. But the indrawn breath when Justice Scalia described the Voting Rights Act as a racial entitlement. And when you heard the kind of questions that were coming from Justice Roberts and Justice Kennedy, and when you then read the opinion, the decision that it's over, the decision that we've reached a certain level and now we need to stop this unnatural intervention. As though the natural state of American affairs is that we would always need intervention to deal with issues of racism. And so I think this is something important for us to remember when Pam says we're kind of back to that first generation. I don't think we can do the generation seriatim anymore. We have to recognize we're always going to be doing all three. We're going to be doing the first generation, we're going to be doing the second generation, and we're going to be doing the third generation, and we've got to figure out how to do them together.
And that actually is a great segue to the other clarifying question I wanted to ask. I wanted to make sure that it's clear to the audience what the three generations are. Pam, you had mentioned that we never got to the third generation that Dr. King had envisioned. In fact, we're still now we're fighting the first generation again. I wondered if maybe you could explain what you mean by that. What are the first generation problems that we thought had been solved and now are cropping up again? In what way?
Yeah, so the first generation is the right to register to vote, to cast a ballot, and to have that ballot counted. And we're seeing problems with all of these, and I'll just give a couple of examples from some cases that I was involved in litigating at the Department of Justice. So the right to register. Some states are now trying to require people to show proof of citizenship in order to register. And for most of you in the audience, that might not be that hard to do because you've traveled overseas at some point, so you have a passport. Or you drive a car, so you have a driver's license from a state that's compliant with what's called Real ID. But for huge numbers of Americans, particularly Americans of color, they don't have the documents that would show that they're a citizen. They're too poor to own a car, so they don't have a driver's license. Or they're too old to still drive, so they've let their license lapse. Or for many elderly African Americans and Latinos in the South, they were born at home and never got a birth certificate. Or the birth certificate was filled out by somebody who didn't have, who had like a 4th grade education, so their name is misspelled on the birth certificate or the like. And so, for example, in Texas, there are 600,000 people who are now registered to vote who can't vote because they lack compliant government-issued ID. So the first thing is it's hard to register to vote, and if you move a lot, and poor people tend to move more often than wealthier people, you have to re-register in some states everywhere you go because the state doesn't really automatically re-register you, although they're supposed to do that. Then there's casting a ballot, showing up on election day. Well, in states that now have voter ID laws, lots of people don't have that ID, and they go to the polls and they're told they can't vote. Or they work 3 jobs because they're trying to keep food on the table and the state doesn't have early voting or doesn't have weekend voting or has cut back on Sunday voting and the souls to the polls. Or they show up at the right place to vote but in the wrong line, and rather than telling them go to the other line, they're handed something called a provisional ballot. And although the federal government requires the state to give you a provisional ballot, they have no rules on whether it should be counted or not. And so lots of people show up and cast a ballot that they think is going to be counted and doesn't get counted. And those problems are all getting worse in part because of the disappearance of preclearance, which is why, for example, Texas was able to put its voter ID law into effect. Alabama is able to put its law into effect. North Carolina is able to try and get rid of early voting or to try and get rid of same-day registration or the like. So those problems are recent problems, and that's the first generation.
Right.
The second generation is about the ability to elect candidates of your choice. It's about the rules that translate votes into wins. And the biggest one in the United States involves the way we draw districts. Because it is probably as true today to say that every 10 years your representatives go into a room and pick you, as it is to say every 2 years you go into a room and pick your representatives. Because the sophistication of the technology for gerrymandering has gotten so much better since the 1960s that now there are huge numbers of elections in the United States in which we know the results 2, 4, 6, 10 years in advance, because literally nothing that's going to happen in the interim is going to change the outcome of those elections. So that's the second generation, which is mostly about things like districting. And there, the Voting Rights Act was critical, and pre-clearance was critical in stopping the covered jurisdictions from changing the way they did elections to make it harder for communities of color to elect candidates of their choice. It's now April of 2018, and we are still litigating whether the plans that were drawn in North Carolina and in Texas after the 2010 census fairly represent the African American and Latino populations in Texas and the African American population in North Carolina. So we're going to get to 2020 with maybe one election conducted under a plan that fairly reflects minority voting strength. That's because in the old days, the Voting Rights Act stopped those plans from going into effect, and courts could draw fair plans in the interim. Or more to the point, it told the states, you're not going to get this kind of plan pre-cleared. And the Supreme Court was vigorously enforcing Section 2, which they're not really doing anymore. So that was the second generation. The third generation is this idea that you don't just care about the dignity of yourself getting to cast a ballot and have it counted, although that's super important. And you don't just care about whether you're able to vote for a winning candidate in your district, but you care about the overall composition of the legislature, because that's what determines who gets things done. You care about the coalitions that your representatives can build inside the legislature. And that's the third generation, and that's the generation that the Supreme Court said the Voting Rights Act has nothing to say about.
Now, thank you very much. Each one of you has mentioned the Voting Rights Act and its centrality, right? And I think obviously that's the case. Dr. King and his work was obviously crucial in the passage of the Voting Rights Act in 1965. If you were to be able to write a new Voting Rights Act today or to make amendments to it, what changes do you think are essential? I'll take anybody.
So I guess there are a number of the problems we've discussed need to be considered, right? But the question is, in what time frame will these things be considered? So let's just be optimistic here and talk about what the issues are and what legislation might consider, because it's important to the voting process and to full inclusion. The key thing that the Supreme Court was quibbling about in the Shelby County case that we keep referring to is the passage of time and when there is a break in history, right? So essentially what they were saying is, because the piece of the Voting Rights Act of which we spoke, the preclearance provision, tended to focus on many parts of the Deep South, not all, but many parts, that had some of the most serious histories of voting discrimination, that the way in which the Congress went about identifying those places could no longer stand. And so that was the core contention of the court, that the evidence was too old and too stale. Now, there are lots of ways to look at evidence, and I think what the congressional record showed is that in many of these places there was continuing discrimination, some of which was being dislodged by the Voting Rights Act and protections that were in place, but that many of these things were continuing. But the other thing the court didn't like about it is that other places didn't have protection at all. And so they felt as if these parts of the country were being penalized, in a sense, in a way that was unfair. And so in order to think about a new preclearance regime, to the extent that's a possibility, one would have to think about what are the claims of history and how long a history do you need to show discrimination in voting to justify it, and how recent does it have to be, right? That's one piece of it. Another piece would be, how can you think more broadly such that you're not singling out parts of the country in the way that Section 5 came to be cast? And so some way that would create a mechanism that hotspots that may develop could be subject to important voting rights provisions. Now, what may not be obvious is that these two things are in tension, in part because one is focused on history and a pattern of conduct, and the other one is trying to contemplate a broader reach that may reach places that haven't had long histories of discrimination, but perhaps are copying legislative efforts or things that are happening in other states. States learn from each other. There are national lobbying bodies that do model legislation. Sometimes it's good, sometimes it's bad, and then legislators take it up and it hops from state to state, right? That's how discrimination metastasizes. And so the very difficult challenge in meeting what the Supreme Court set out in Shelby County is thinking about a way both to value the claims of history, but also to think how you sweep broadly enough that you're not over-selecting a particular part of the country. And then, of course, if you're speaking ambitiously, you would think about changes that might go to some of the other barriers, like felon disfranchisement or other things, which has a place in the Constitution, but perhaps could have more robust efforts to dislodge because of the extent to which it's practiced.
I'd add also that if we're thinking ambitiously, I like that term, rather than optimistically and naively, I would love to see Congress has power not just under its power to enforce the 14th and 15th Amendments, the power to enforce the Equal Protection Clause and no discrimination on the basis of race in voting. Congress has power in another part of the Constitution, the Elections Clause, to pass rules for the conduct of congressional elections. So there's nothing that would stop Congress from having universal voter registration for all federal elections across the country. I mean, if we're talking ambitiously, why shouldn't it be that we have a national, nonpartisan federal election board that is proactively registering every voter in the country and that keeps track and that lets you vote in these federal elections anywhere you are in the United States? So I think we can, we're not close to being there yet, but we should set a marker out where voting should be as easy as an app on your smartphone, not to actually cast the vote that way, but our technology is such that when we move, when we do things, everybody keeps track of us. All of our personal data should be pretty easy for us to be able to have that happen when we vote. And it shouldn't be that you have to spend so much time with voter registration drives and getting people eligible to vote. It should be a no-brainer that if you are an eligible voter, it's going to be easy for you to cast that ballot in a way that's going to be fairly and accurately counted.
Yeah, if I could just build a little on what Rick is saying. You know, every other democracy in the world, every other advanced democracy in the world makes it easy to vote. The government keeps track of things in ways that enable people to vote easily. And in almost every other advanced democracy in the world, even people, not just people who have finished serving their sentences, but people who are still incarcerated have the ability to vote. The South African Constitutional Court required it in South Africa. The Canadian Supreme Court required it in Canada. In Germany, they view it as part of the rehabilitation of prisoners. In Israel, the guy who assassinated Rabin is still entitled to vote while he's in jail. So, you know, the United States is really an outlier here, and it's an outlier here because of racism in the criminal justice system. And if it weren't for that, we would have gotten rid of felon disenfranchisement long ago. Here is a stunning statistic for all of you that I calculated by looking at the 1870 census. I calculated how many African American men there were in the United States in 1870, because that's the group of people who were enfranchised by the 14th and 15th Amendment, since women couldn't vote. There were more black men who were disenfranchised by offender disenfranchisement in 2000 than were enfranchised by the 15th Amendment in 1870, right? And here's another statistic that's stunning, but shows that if we had the political will to do what Rick is talking about, we could do it, which is, there's a part of the Voting Rights Act nobody talks about anymore, which was Section 6 of the Voting Rights Act. It appointed federal examiners in the South, federal civil servants, to go and register people in the counties that were the most recalcitrant. And in the 2 years after Section 6 was enacted, the federal government registered more African Americans in the South than had been registered in the previous 70 years. So if you have the political will, the technology enables you to register everybody to vote. And we should expand the voting period so it's not just on a Tuesday between 7 a.m. and 7 p.m., which is difficult for people who have lives on the margin, but it should be a 2-week period, including weekends, including nights. And if you did that, that would increase the number of voters dramatically. So I don't think that we need preclearance for the first generation problems. I think those problems could be solved if we had the political will. The second generation is where I think you need something like preclearance, because otherwise the cost and the difficulty of litigating these cases through to a final judgment is prohibitive. And you just can't attack those kinds of gerrymanders that dilute, either intentionally or unintentionally, the voting strength of racial minorities through litigation brought by the very few organizations that are committed to this full time, especially when you have a Justice Department that's completely not committed. And that's one of the things to understand about preclearance, is it goes through the Justice Department. So if you have a Justice Department like our current one, which is headed by a man who was too racist because of his attempts to suppress black voting strength to be named a federal judge in 1986, preclearance is not going to save you.
Charles.
So I agree with all that's been said. A couple more things, though. I do think that on the issue of felon disenfranchisement, you know, I think that it would be interesting if we were thinking ambitiously to think about what those fixes could be. You know, Pam referred earlier to, you know, racism in the criminal justice system. The idea that you can hide behind this, you know, constitutional provision in the 14th Amendment that allows you to disenfranchise ex-offenders while maintaining a criminal justice system that is rife with racism of the sort described in the previous panel seems to me to be, you know, a constitutional sleight of hand that simply should not be permissible. And so it seems to me you could, in this new expanded Voting Rights Act that included a national preclearance provision of the kind that Debo talked about, that included universal registration of the kind that Rick talked about, that maybe included automatic registration for everyone 18 years old or above, that included the kind of expanded voting time that Pam talked about, certainly if not 2 weeks, certainly we could do 2 days, we could do a weekend, that it could also include a provision that described the circumstances in which you cannot disenfranchise ex-offenders, and that is if the criminal justice system is determined to have several markers or factors that demonstrate that the existence of racism in the criminal justice system, then you are not allowed to use the ex-offender status of individuals to keep them from voting. And you might create a kind of jingles test, a kind of set of factors that would determine whether a criminal justice system in a particular state or jurisdiction had the effect of disenfranchising disproportionately African Americans because of the presence of racism as an objective factor. I think beginning to think about what this means when you allow racism in one area to bleed into another area. This is precisely, in fact, what the Voting Rights Act was meant to deal with. You know, the genius of the Voting Rights Act is that it did anticipate the future. Debo was talking about this earlier, the tension between the progress of the past and recognizing that there's still work to be done. By its very terms, that's what the Voting Rights Act was meant to do. When you read the Senate report that accompanied the Voting Rights Act, in which Congress was clear that they wanted to get at not only methods of disenfranchising African Americans that existed in 1965, but they wanted to get at what they described as those ingenious methods that they couldn't even think of yet. They recognized that in the future there would be new ways of disenfranchising African Americans, and the whole preclearance process was created to capture what might happen in the future that they couldn't anticipate in the moment. So I think when we think about a kind of renewed Voting Rights Act, that's how we should be thinking about it. We should be thinking about an act that leaves enough room for the recognition of what I described before, the ongoing reality of racism and racial manipulation. I think Rick was talking about the ways in which race has been kind of deployed by the political parties, first by the Democrats and now by the Republicans, as a way of controlling the electorate. And I think that that's a reality. That's not a theory. And so that has to somehow be factored into, I think, any recrafted legislation that attempts to seriously engage the question of racial discrimination in voting. And I just say as a last point, it requires first an acknowledgement of the core anti-democratic nature of racism in voting, right? Pam referenced the voter ID case in Texas. We know about the voter suppression law in North Carolina. These are two laws that have been found by federal courts, federal appellate courts, to be discriminatory. In the case of the North Carolina court, it was the Fourth Circuit Court of Appeals that found that the voter suppression law that ended souls to the polls and so forth was created with surgical precision to discriminate against African American voters. In Texas, the trial court found that the Texas voter ID law was created for the purpose of discriminating against African American and Latino voters. Now, we've had lots of conversations over the last year after post-Charlottesville about white supremacy in this country. But I think when we have the legislatures of two states that have been found, not by the nice people on this panel, but by federal courts to have met and converged and deliberately passed laws for the purpose of disenfranchising minority voters, we have a democracy problem. And it's that kind of recognition that produced the original Voting Rights Act, that when they stopped, judgment at Nuremberg and people saw what was happening on that Edmund Pettus Bridge, people saw we had a democracy problem. And what's interesting to me is, though, that despite the fact that we have these two federal court decisions, and many others, by the way, despite the fact that Texas hasn't had one redistricting since the 1970s that hasn't been found to be racially discriminatory, despite that fact, we don't see this as a core democracy problem for the nation. Because if we did, Congress would be at the table trying to figure out how do we solve this democracy problem. And I'll say that I think the urgency of seeing it as a democracy problem, I'm giving you a segue here, is reflected by what we saw with the manipulation of race by Russian operatives in the election in 2016. That even foreign governments know about our race problem and know that you can manipulate race in elections. And so I've been describing racism in our election system as a national security vulnerability, that like anybody can see it and manipulate it. So I think that we do have to turn to seeing this as a democracy problem, and any legislation that we can create in this mythical future when we have a Congress that has the courage, the spine, the willingness, and the patriotism to do so has to see it in that framework, that they are resolving not a problem of just Texas or this county, but a democracy problem for this country.
Thank you, Sherrilyn. Thank you. So far, everything we've been talking about has been focused on the federal level, and to the extent we've referred to state action, it's been in the negative. Some of the voter ID stuff that states have done, some of the citizenship requirements for registration and so forth. Are there any developments on the state level that you would describe as positive in terms of election reform, voting reform?
Sure. So, I mean, this is one of the problems, and this is the Civil War continuing to today. As you look at the Union states, and a number of them have done some bad things, but a number of them have done terrific things. So, in California and in Oregon, the secretaries of state are moving towards automatic voter registration, so that people will automatically be registered, and that cuts down on difficulties. They've made it easier for people to vote by mail if they want to vote by mail. Oregon sends trucks in its vote by mail to senior citizen centers to help senior citizens vote and like. So that's one thing that you see some states doing that I think is a lot better. We've actually done much better on the legislative level than on the judicial level in offender disenfranchisement. A number of states have moved away from lifetime felon disenfranchisement. There are only 2 states that allow people who are currently incarcerated to vote, but a majority of states now allow people who have finished serving their sentences to vote, and that makes a huge difference for a lot of people. And some of those states just automatically re-enfranchise people after they've finished their sentences. So it's not like nothing can be done, and there are some state and local election administrators who make major efforts to see that the machines work properly and that the poll workers are trained. Right before I went to give a talk last June, I was I had to vote absentee for the first time in a long time. Although California allows you to vote absentee automatically, I like to go to the polls because I actually think there's something important about standing in line with other people. It's disgraceful if you have to do it for more than about 20 minutes, but there's something deeply important about citizenship and casting a ballot as part of your public citizenship, as opposed to doing it at home where you start to think about it more as a private activity. But when I went to the polling place, there was a Chinese-American woman who was ahead of me in line, and she was having trouble, and the poll worker came over to her and said, "We have ballots in Chinese. I'll give you the ballot in Chinese. Let's just tear that up and start over with a new one." So there are people who do a conscientious job of this. It's not as if it's a bleak thing across the country. The problem is that in the places where African Americans and Latinos vote, especially in places where they're an increasing share of the population, it's no surprise why Texas is doing what it's doing. Texas is the first state in the country to become a majority-minority state other than Hawaii. But first state in the continental United States, and it's no secret that part of the reason they're doing what they're doing is to decrease the share of the electorate that's African American and even more so Latino. So it matters where you are in the country to whether you have an election system that says count every vote, or you have an election system that says count some people's votes and not others.
If I could just add to this idea of what I've called red state election law and blue state election law. The problem is, this goes back to my earlier point about Congress's power, although Congress has the power to make uniformity in elections, our general view is a federalist view that it's not only that we don't have a federal election, we don't even have state elections, we have local elections, right? So when we conduct the presidential election, it's like 10,000 separate elections. And so there's a tremendous, when there are no uniform federal rules, there's a tremendous amount of discretion, especially local discretion. And without Section 5 of the Voting Rights Act to make sure that last-minute changes are not happening, things are flying under the radar. Things are happening in places that we don't even know about until it's too late. And so federalism has a lot of virtues. Even in the election area, it has the virtue that if there's hacking of machines, it's not going to affect us nationally. But I do think this is an area where it shouldn't be that if you live in California, it's really easy to vote and everyone's enfranchised. But if you live in Texas, you might have to travel 250 miles to get your free voter ID if you live in a rural area. So it's not a way to have equal dignity of citizenship across the United States.
I'll let Sherrilyn and Debo speak to this last question in a moment, but at this point I would like to start moving towards questions from the audience. So if those of you who have questions from the audience, please come up to the two microphones. I'd like to sort of alternate between the person who's at the front microphone and the person who's at the rear microphone. And because of the lights, I can't see the rear microphone. So it's an honor system, so please just try to help self-regulate here if you don't mind. And we'll let our other panelists finish on that last question if you want to.
So on this question about what the states are doing, I think it's a very interesting and important question. When we learn about our system of government, we talk about the states as laboratories in our democracy. And we've seen a lot of retrograde measures. We've spoken about some of them and where they're happening. And I think that there were many states that for a long time were asleep at the switch, meaning folks were so focused on the efforts to narrow the electorate and to prevent people from voting that there weren't enough states that were leaning forward to say, what is it we can do to expand democracy? And I think it happens for a couple of reasons. There's this thing that undergirds so much of the discussions about voting in America, which is this concept about whether you envision voting as a privilege or as a right. And I think there are many people who view it as a privilege that has to be earned. And if you look at the history of our registration and our inclusion and who could vote over time, we jealously guarded the right to vote. We have very jealously, as Americans, guarded the right to vote. Pam spoke to this a bit, but over time, groups have been added, often through constitutional amendment, and these additions of people coming into the electorate have often occurred after wartime. That is to say that we have gone to export democracy or talk about defending freedoms overseas, and young people have died for this, and then they come back and they're asking the questions about what kind of democracy we have at home. Alexander Kesar wrote a great book that charts the extent to which voting progress has happened after wartime, when the country has had to look inward and talk about moving forward. Now, we've been in an extended period of war, and we've seen the ebbs and flows, but now we're hearing about these states. Oregon, Washington State, a couple of weeks ago, passed an automatic voter registration and a pre-registration for young people, where high school students who are 17 or so can pre-register and take the necessary steps such that when they become 18 and eligible to vote, they will be on the rolls. Now, registration is important, but that's a first step. You also have to get people out to the polls, right? Because lots of people register and don't go. But what they found in Oregon, looking back at the automatic voter registration, is that many of those people who were automatically registered did vote, and there were some studies done to look at who are these people who were registered, and they tended to be younger, more rural, lower income, and to some extent diverse, to the extent that happens in Oregon. And so I think these are important things, but undergirding the choice about whether you're trying to open up the democracy or close it off is this concept of, are you thinking about it as a privilege or a right? And also, are you committing to the idea that in a democracy, we are choosing risk? We are choosing the risk that our people won't be elected and that sometimes somebody else is going to win. And part of what you see in these voting battles are that people are not willing to accept the risk that democracy imposes upon us, that people should have an opportunity to come forward and choose, and your side is not always going to win. Many of the things we've talked about are efforts to put your thumb on the scale to control the outcome or to exclude a certain segment that you think may not be aligned. And I want to live in a democracy where we're prepared to let people vote and let the chips fall.
Just a couple of things. So 51% of black people still live in the South. And so when we begin to talk about the progress that's happening, we're usually, as Pam suggested, talking about somewhere along the coast. And so we're still not getting at the core of the issue of race and voting. And I think we have to be clear-eyed about that to recognize the challenge that we face. I think we also have to recognize that, as has been alluded to, we're not actually just talking about at the state level, we're talking about at the local level. This is something that I learned my first tour of duty as a young legal defense fund lawyer, and Pam knows this well, that much of the litigation that I participated in involved local elections, involved, you know, the school board and the town council and constables and justices of the peace. And what I learned was that these were the offices that really controlled the lives of the people who we were representing in many of the communities where we worked. And one of the reasons why it's very difficult to solve problems at the local level is that this country's entire conversation about voting is really focused on, first, the national, and second, on the two political parties. And so everything is seen through that lens. And that makes it very difficult to have real conversations about the kind of thing that Debo was just talking about really the conception of what role voting plays in our society. We saw this last year with the special election, Senate election in Alabama. Now, LDF does a lot of its voting rights work in Alabama. We're currently challenging Alabama's voter ID law. We're in Alabama every election day doing poll watching. That's where I did poll watching in November 2016. You know, everyone said, why aren't you in a swing state? Because I run a nonpartisan organization, because I'm actually old enough to remember when we still sued Democrats in voting rights cases also. And so I spent November 2016 in Alabama, and I know what I saw on election day in November 2016. Now, nobody cared about it because that wasn't a swing state. Last year, in the special Senate election, people cared about it a lot because now this was a national election. It involved the balance between Democrats and Republicans in the United States Senate, and suddenly everyone was in Alabama, and they were seeing the things that we were seeing. We spent the day there, and we saw all the things that Pam was alluding to about people showing up and, you know, not being told that they were in the wrong line, and being told that they could, you know, cast provisional ballots rather than regular ballots, the wrong voting machines turning up at African-American precincts. All of this. I was put off of a precinct in November 2016, literally told that I had to leave, and after weighing it for a minute, I decided they were serious and that I should go. But this is real, and this is happening at the local level. So I think turning our attention away from thinking about politics, voting, participation, and democracy as just being a national matter, and remembering that it functions most effectively, most powerfully, and often most disastrously at the local level. and beginning to turn our attention to that is really important. Now here I do see some progress. I think the election of some of these progressive prosecutors is one of those things that's not just been limited to the coast, right? That the election of the first black DA in Florida, Aramis Ayala, who immediately then ran into a third-generation voting problem when she decided not to pursue the death penalty in a number of cases and was challenged by the governor, the election of a black DA in Alabama. I mean, I think we're beginning to see some of that transformation happening. But I do think that to the extent we're not focusing our attention on the local, it's vitally important. And then just because this is a panel about Dr. King's vision, I would be remiss if I didn't say, as it relates to those local elections, we also have a responsibility as well. And this is not just about the apparatus that's designed to keep us from participating fully in the political process. We have to actually believe that those elections matter. We actually have to vote in school board. I mean, I know when you go to the polls, you're going to vote for the president and the governor and the senator, right? And maybe the mayor. But are you voting in the school board election? I mean, every one of us has faced a judicial election in which it says pick three, and we actually don't even know who the three are. Maybe we know one of them, but we pick three based on political party or whatever else we think. We haven't really taken the time to educate ourselves about who those judges are. We haven't taken the time to educate ourselves about who those DA candidates are. We haven't taken the time to educate ourselves. I mean, here I've heard the name Sheriff Arpaio this morning, right? We all know Sheriff Bull Connor, right? We know Sheriff David Clark. Sheriffs run for election. And to the extent you're not paying attention to those sheriff's elections, you're not educating yourself about who those candidates are, and then you're not voting in those elections. I mean, to me, this is like so beyond even thinking about like what you're doing in the presidential election, because this person is patrolling your community with police power, and then we want to talk about, you know, inequities in the criminal justice system. So I do think that it would be remiss of me not to talk about the fact that Dr. King also recognized our role. His presumption in Give Us the Ballot is that we would exercise that ballot responsibly, that we would educate ourselves, that we would recognize that every election counted. When he talks about all of the elections, he goes from the top to the bottom. And the question is, do we do that? So I do hope we'll leave this conference with a renewed sense that even as many of us are fighting these structural impediments to voting, there is a role for us to play in terms of really paying attention to those local elections and paying attention to what our role can be in tipping the balance in many of those races.
Thank you very much, and we'll go to our first question up front here.
I want to thank all the panelists, first of all, for an excellent discussion. When Professor Karlan was talking about first, second, and third order questions, and Ms. Ifill mentioned the democracy problem, made me think about an issue that's been in the news recently that y'all didn't bring up, which is the citizenship question on the census. And I'm interested, first of all, Professor Karlan, do you think that's a second order question or an antecedent question? I think that's just kind of an interesting conceptual matter. And also, I saw a panel on Fox News Sunday yesterday where they were talking about this, and no one mentioned Article 1, Section 2, Clause 3, where you have to count the whole number of persons. And, you know, Jason Chaffetz, formerly a member of Congress, said he was shocked that, you know, he was elected by people that were counted more than just citizens. And I'd like y'all's reaction to that. Thank you.
Okay, great question.
So if there's anybody who hasn't been following this, the Trump administration has proposed putting a question on the census that's going to be conducted in 2020 that would ask people about their citizenship status. And there are a couple of problems or issues that arise out of this. The first one is that putting a question on the census that asks people about their citizenship makes it less likely that a number of people will answer the census at all. And we already know that there's a serious undercount in communities of color. That is, the census doesn't capture all of them. That's a problem because a couple of things that are very important flow from the census. The two most important ones are the allocation of seats in the United States House of Representatives. And as you alluded to, the Constitution says those seats are supposed to be allocated based on the number of inhabitants, not on the number of citizens in each state. But the second thing that flows from this is a huge amount of federal money that goes back to the states is given to the states based on their population. So if your state's population isn't accurately counted, your state gets less money in block grants for education and health care and transportation from the federal government. So the first problem with the census question is going to lead to an undercount. That undercount is not going to be random. It's going to be more of an undercount among African Americans and even more so an undercount among Latinos, and that's going to reduce the political power of the states in which they reside. The second problem comes from how, having gotten these seats in Congress, how you redistrict, how you reapportion your seats within the state. and how you also set up state legislative seats, city council seats, county commission seats, and the like. Because what people are worried about is not just the undercount here, but the fact that some states will be inclined to use citizenship numbers rather than population numbers to allocate the seats they're given for Congress, or to allocate seats in their state legislatures and the like. And this is going to lead to a dramatic underrepresentation of Latinos and a slightly smaller but not insignificant underrepresentation of African Americans. That's mostly going to be about Latinos, though. And the important thing there is it's a third-generation issue, because if those people aren't electing, if those communities aren't electing people to the legislature, they're not going to be at the bargaining table, and they're not going to be at the bargaining table in the same numbers as they would otherwise be.
Anybody else want to speak to that?
Yeah, I just want to say very quickly that it is also, well, let me say two things. First of all, it matters that the intention of this is to do all of the things that Pam just described. That's a democracy problem, right? That notwithstanding the very words of the Constitution, that there is a deliberate attempt to do precisely what Pam described, just to ensure that there is an undercount and to produce all of the collateral consequences that she described. But I do want to say this is also a matter of governance and services. If I'm the mayor of a town and I need to allocate sanitation services, if I need to think about where we allow housing to develop and so forth within the community, I want to know who lives there, because I still have to serve those people. If I want to determine whether or not we need a bigger high school or we need a bigger elementary school, I still have to serve that population, whether they are citizen or non-citizen. And so I would want that accurate information. But to allow, in fact, to encourage a kind of public policy that deliberately ignores the needs of the non-citizen population is cynical indeed, but is in fact quite deliberate. And I don't think this is any speculation. I actually my first job as an adult was as a census enumerator with the little bag that was slung across me when I was 18 years old in 1980, do the math. So anyway, the point is, and I know what it took. This is, and one of the great things about being a census enumerator is that you learn about communities, in this case, my own community, and to learn what it takes actually to get people to talk to you, and to see all of the reasons why people don't want to talk to you, and who you have to be to have people open that door and answer the questions of how many people live in that home and so forth. This really is a matter of delicacy and balance, and there is no question that including a question like that will make some people not open that door because their cousin is undocumented and has been staying with them. And they themselves are fully legal, right? But because and if you combine it, you can't divorce this decision from what everyone has seen happening with these ICE raids. If you have seen it, if you have seen families torn apart, if you have seen fathers and mothers have to leave their children, then answer the question, would you open the door if you knew that an undocumented cousin or an undocumented aunt or even friend of the family was staying with you? If you had witnessed that kind of tragedy. So you have to put these things together and understand this is quite deliberate. And this is what I mean when I say we can look at all of these things seriatim, but I think it would behoove us at this moment, and this is the way that Dr. King thought when he thought about the sickness of the nation, to recognize that we have a democracy problem. We don't just have a political party problem or a voting problem in a particular place, that each of these things is a reflection on the strength, the health, and the vitality of our democracy nationally.
Thank you. We're going to go for another 10 minutes before we break. We're going to try to get through as many questions as we can. I apologize in advance. We probably won't get to all the questions that we have. If we could go to the next person in the back.
Hi. I have, I guess it's sort of an observation / comment I'm hoping you might respond to. And it connects the first panel up to this one. I noticed, I was struck by that many of you on the panel were using the word racism very directly and saying that these problems are a problem of racism, which I agree with. But I found it an interesting contrast with the first panel where there was much more discussion of implicit bias and less of a direct calling out of using terms like racism for a variety of reasons. And implicit bias is a real thing, it's a real problem, it's a real concern. But I also find that if we, to the extent we start using implicit bias as this sort of way to explain what most of race relations is about in this country today. It's a more comfortable way of talking about racism, that it also allows us to sort of consign explicit racism to the past, or to just to tiki torch Nazis and nothing else. And in many ways, that the rise of the talk or focus on implicit bias, I think, has enabled a decision like Roberts in the Holder case in Shelby County that sort of dismisses the past, right, and say racism isn't an issue, things have changed. And one way we do that is by saying, oh, well, there's implicit bias, but racism is really a thing of the past. And so I'm just wondering how you might sort of think about the relationship between racism and implicit bias in the work you're doing.
Maybe I'll start. So obviously both are important, and I think one way to consider your question is to think about what is the impact of whether it's racism or implicit bias on the person that is receiving the downside of the view, of the treatment, of the decision, right? In both cases, it's having an effect of narrowing opportunity, sometimes of risking somebody's life, of narrowing full enjoyment of citizenship. And so my view is that it's bad no matter how it's happening, and it may require different ways to get at it if it's implicit bias, and so it's less upfront and in your face. But the other piece of it comes from the history. And the history is that over time, because of the civil rights revolution and all of our history, people have come to understand that you can't always achieve discriminatory ends in the same way that you used to be able to do it and stand out on the courthouse steps and say, you know, segregation now, segregation tomorrow, segregation forever. That won't work in most cases today. And so there are federal court decisions that talk about how would-be discriminators have become sophisticated over time and try to cloak their intent. They don't make it manifest. Now, we still see cases where it is manifest. Sherrilyn mentioned some of them, and courts are willing to call it where they see it. But that's a reason why in the civil rights litigation, the effects standards, the results standards that try and ferret out inexplainable disparities, disparities that are not explainable through rational discourse, and try to get at them through a results test or an effects test, are so important, as well as the intent cases. Now, the thing that I'll say finally about the intent cases is that it's very hard to have people call other people racist, because people feel it's difficult, it can be isolating and all of that. Sometimes you need to call it where you see it, but it's hard for courts to issue a ruling that adjudicates a legislative body or a law enforcement officer or a teacher or anybody else as being racist. And so these different tools in the law are in part a response to the difficulty that some people have of calling things what they are. And I think we shouldn't lose sight that regardless of how discrimination is being visited, whether it's consciously or not, it still has a negative impact that should be answerable in our laws.
I'm thinking of, there was a Simpsons episode where there was a banner flying. It said, Fox News, not racist, but #1 with racists. It goes back to this issue of racially polarized voting that I mentioned earlier. We know that, especially in the South, whites and African Americans tend to vote for different candidates. And even if you just look at Democrats, so you look at Clinton versus Obama in 2008, same thing is true. And so the parties have found a way, and lately it's been the Republican Party has found a way to harness white racism in order to achieve political ends. And this a kind of intersection between between partisanship and race in terms of motivations makes it really hard for the courts to deal with the problem. But whether you deal with it one way or the other, it's a real phenomenon that the courts need to take cognizance of.
I'm afraid, just 1 second, Pam. I'm afraid we'll have time for only one more question, so we'll take the question of the person up front. If you want to speak to that other point, please go ahead.
Okay, so I was just going to say, you know, there was a tremendous victory last year at the Supreme Court that Sherrilyn was part of in a case that involved such overt racism, the Buck case, such overt racism that even the Supreme Court couldn't deny it was there. But I think what happens with cases like that is it allows the conservative justices to tell themselves they're against racism because look what they did when there's a case of complete racism in which a man was sentenced to death because there was testimony at his trial that black people are more dangerous than white people, right? And so that allows the Supreme Court to tell themselves, well, we still care about racial justice, but then they don't see the problem when it's the vast majority of cases today that don't involve overt, express discussions of racism. And I think, and this is an important point that Debo made as well, it's important to say there's not just explicit bias and implicit bias, there's also the legacy of hundreds of years of past discrimination that even people who have no bias at all engage in. So if you have a requirement for a job that there be a college degree, you might not have that because you're trying to keep black people out. You might not even have that because implicitly you're trying to keep black people out. But if because of our educational system fewer black people have the opportunity to get a college degree, that's discriminatory and we need to do something about that. And that it's that last category that I think we really should be especially focused on because lots of people think that's not a problem at all. That we declared victory and went home. And Roy Austin's friend, Jeff Sessions, has announced, he's finally seen the light. And that's a terrible, terrible problem that we haven't really confronted directly.
I told you you'd have the last question. If you could keep it brief, and panelists, we could keep it brief as well. Well, this will be our last question.
Steve, I'm a lawyer too. We can't be brief. I want to thank Debo for introducing, first of all, the panel was outstanding. Thank you for a very complex subject. I really did it. I want to thank Debo for introducing the subject of war into this complicated discussion to make it even more complex. I was a trial attorney with the Civil Rights Division on August the 8th, 1965, when President Johnson signed the Voting Rights Act. And one of the proudest moments in my life was when Barack Obama was elected president of the United States, because there was a direct relationship between that act and his election. And when he placed the Medal of Honor, the Presidential Medal of Honor, on John Dorr's neck and said, I probably wouldn't be here if it wasn't for John Dorr, he could have dropped out probably and just said, I wouldn't have been here. So it was a really extraordinarily important and almost radical piece of legislation, radical in the positive sense. But, with all of this, if you have these damn wars, and Dr. King saw that, Dr. King was a prophet. He saw that. And that's why he spoke out about it and was willing to risk the whole movement because of it. So this whole subject just covers all of this stuff, this subject of our nation going to the war. I mean, Vietnam, clearly horrible mistake. In the invasion of Iraq, 20 years later, we're still magged down in a problem that's not ours. We're out there creating problems is what we're doing as a nation. We're the Roman Empire. And when you read history, something happened to that empire. And so I'll leave you with that and get just
Okay, all right. Thank you very much. Any comments to that? Any responses, any comments? Okay, before we break, I wanted... Oh, sure, please, yeah, go ahead.
Only that in the last year of his life, Dr. King was very clear about the three evils, right? Racism, poverty, and militarism. And he, although he got a lot of pushback, including from the civil rights community, about addressing the issue of militarism, he said he would not pretend that these three things were not intertwined. And he would not be silent about any of them, and that he thought it was important to talk about them. And so I appreciate that comment. I also think that it is really vitally important, and I really want to just address this to the prior question as well, that we be unafraid at this point, 50 years after the assassination of Dr. King, to talk explicitly about racism and the way in which racism is a cancer eating away at our democracy and always has been. and that we not be afraid to talk about it, that we not be afraid to talk about it being explicit or implicit or legacy, but that we recognize that it remains with us and we recognize the danger of it. And for that reason, I think actually it's important to talk about implicit bias, because implicit bias is meant to address the reasons why good-meaning people will tolerate the explicit bias of others, right? It's why in terms of the first panel, it's why, despite the fact that there may be explicit bias happening in some of these cases of shootings and so forth, why good-meaning people are willing to allow it, are willing to give it a pass. And that it's important. It's an important thing for people to recognize the role that that can play. But explicit bias is back on the stage, actually. In full effect. You know, we sued the president this past year about this election commission, and we sued him on the grounds that it was intentionally designed to discriminate against minority voters, against African American and Latino voters. We weren't ashamed to say that. I think it is a shame that is true of a president of this country, that president can be engaged in explicitly racially discriminatory rhetoric, comments, and actions. I think that's a shame, but I think we do have to call that what it is. Doesn't mean implicit bias doesn't exist, but it does mean, and we'll never know what happened with that case. Obviously, the commission had to be disbanded, but I think it's important in this moment to recognize that explicit bias is fully back on the table. That's what I meant when I was talking about the cases. That's what I meant when I was talking about the decision about the census and the citizenship question. These are explicit actions designed to suppress a part of the population that is racial minorities. And the fact that we are here today for this anniversary means we have to talk about it. We have to talk about the fact that that is still stubbornly with us and that it still threatens to corrode our democracy.
Thank you. Thank you. If I could, two things before we break. The first is I want us all to thank our great panel. And the second is a program announcement I've been asked to make. So the next panel will continue at 2:15 back in this room. And if you are pre-registered for the luncheon, then you should go now to the grand ballroom. You can go out that door and turn right, and then people will guide you to the grand ballroom. The luncheon, if you're pre-registered for... Thank you. That was great. Great comments. Thank you.